la plus simple et plus lisible. Quelques questions. J'ai essayé de comprendre quelles étaient les raisons de la non-effectivité sociale de cette norme en France. J'ai essayé d'interroger les juridictions françaises concernées afin de leur demander pourquoi elles n'étaient quasiment jamais saisies par ce genre de procédure. Et on peut aujourd'hui s'interroger sur l'intérêt juridique de ce règlement.
Okay. So this is something which is different from what Sandra says. In France, it clearly appears that the justiciables have a clear preference for the national procedure, and so Alexandra Meus has done some interviews for judges to find out why.
Alors, les interviews, au départ, mon orientation a changé. J'avais prévu d'interviewer les juridictions de proximité compétentes en la matière en France, et mon plus gros travail a été de trouver les juridictions qui avaient pu être saisies de ce genre de litige, parce que beaucoup d'entre elles n'avaient jamais même entendu parler de cette procédure. Alors, simplement un petit rappel, en France, les juridictions compétentes sont le juge de proximité, qui est compétent pour les petits litiges jusqu'à 4 000 €, et le tribunal de commerce. Donc ce sont les deux juridictions qui sont saisies de ce genre d'affaires. Quelque chose de nouveau aussi en France, c'est qu'à partir du 1er janvier 2013, il n'existera plus de juridiction de proximité en France. Donc, on pouvait s'interroger sur le fait de savoir si l'absence de saisine sur le fondement de ce règlement communautaire était peut-être liée au fait que le juge de proximité n'est pas un magistrat professionnel et que peut-être il y avait des difficultés d'ordre technique. Aujourd'hui, on se dit peut-être que demain, comme c'est le tribunal d'instance qui va reprendre ce genre de procédure, peut-être qu'on aura plus de litiges, mais clairement je n'en suis pas sûre. Enfin, ça n'est pas entré dans la mentalité du justiciable aujourd'hui d'utiliser le règlement communautaire à l'appui d'une prétention. Les raisons que je pourrais invoquer, en France, on verra à partir du 1er janvier 2013, les choses évolueront certainement, mais on a eu un problème d'imbrication de compétences entre le tribunal d'instance et la juridiction de proximité. Cette juridiction n'a jamais réussi à trouver sa place dans le paysage juridictionnel français. Et par rapport à ce règlement communautaire, finalement, eh bien, la tendance a été de remarquer que lorsque un litige arrivait au greffe du tribunal, comme la juridiction de proximité, le tribunal d'instance, travaillent au même endroit, eh bien, la tendance était que le juge d'instance s'approprie la procédure et finalement la juridiction de proximité n'intervenait jamais. Pour autant, on pouvait croire que cette juridiction-là était celle qui devait théoriquement statuer là-dessus.
Okay, in France there's two judicial instances that deal with such matters. There's the juridiction de proximité, I don't know if you can translate that at all, and there's the tribunal de commerce court. The juridiction de proximité is responsible for claims until 4,000 €. And one of the reasons why the small claims procedures may be less popular is because it was not clear who to go to. There is a conflict of competence between, or inclarity of competence between the two. And at the clerk, maybe there's an interaction which is more with the tribunal, so that the jurisdiction de proximité loses out. Anyway, this is a problematic institution anyway, because the jurisdiction de proximité are not career judges. They are people who do it next to their own career, so maybe there's a problem with quality too, so that this instance was less in demand, and also for the same reason as from 1st of January 2013, the juridiction de proximité will no longer exist. So this means that for the purpose of this research, there has always been a difficulty to find out where the cases are or where they will be.
Alors même si aujourd'hui la nature du contentieux a évolué en France et même si le nombre de petites affaires augmente, on se rend compte que cette norme, ce règlement communautaire est très peu connu. Je vais vous donner un exemple. En effet, la majorité du contentieux, si nous pouvons parler de majorité du contentieux, concerne le droit de la consommation, en fait, comme le disait Sandra. Alors, je vous donne un exemple. Un consommateur français a commandé par Internet un appareil pour tailler sa haie. Et l'appareil arrive dans sa maison endommagé. Donc il se dit qu'il veut agir à l'encontre de ce vendeur, et le vendeur est situé en Allemagne. Le montant, la valeur en litige s'est levé à 85 €. Donc ce qu'il a fait, c'est qu'il est allé saisir la juridiction de proximité en France, et alors on lui a répondu, je vous cite, « Mais cette procédure ne peut pas être engagée car on ne la connaît pas ». Le juge de proximité a répondu cela. Donc, voilà. Alors, on a effectivement ce genre de problème. Et puis, nous avons également d'autres choses. Lorsque les juridictions de proximité sont saisies, et même celles qui sont très proches des frontières, eh bien, les juges de proximité à qui je me suis adressée m'ont dit « Mais ces procédures, elles se comptent sur le doigt de la main. Elles n'atteignaient pas 1% du total des demandes nouvelles qui étaient enregistrées par le greffe civil. » Donc c'est vraiment extrêmement limité. Alors, autre élément qui a été mis en avant et qui expliquerait la non-utilisation de ce règlement communautaire, c'est la langue. Le problème de la langue, lorsqu'il s'agit de petites valeurs en litige, 90 €, 100 €, 200 € grand maximum, et lorsqu'on dit au justiciable qu'il nous faut traduire les documents en langue anglaise, le justiciable a peur, le justiciable se dit « il faut que je fasse appel à un avocat », et alors finalement cela augmente les coûts de la procédure. Donc une procédure au final qui était simple et peu coûteuse, eh bien le justiciable lui a besoin finalement ne souhaite pas entrer dans cette procédure qui finalement sera pour lui plus coûteuse que prévu. Donc voilà ce que je voulais vous dire par rapport à l'utilisation de cette procédure en France. Peut-être que avec le tribunal d'instance qui reprendra cette procédure, le justiciable comprendra peut-être mieux qu'il doit être accompagné par un praticien du droit, par un avocat. Et puis un autre élément, on peut en effet peut-être se dire que l'imbrication difficile entre la juridiction de proximité et le tribunal d'instance bloquait aussi l'utilisation de cette procédure. Aujourd'hui, il est clair que le citoyen préfère la procédure d'injonction de payer, par exemple, qui est une procédure purement nationale. Ensuite, ils font appel à un huissier pour demander l'exécution à l'étranger. Aujourd'hui, c'est cette procédure-là qui est très fortement utilisée en France. Juste pour terminer, je voulais simplement préciser qu'en effet, ce règlement communautaire, on l'a vraiment accueilli, nous, de manière très enthousiaste. On se disait bien évidemment, cela va contribuer à une uniformisation de la procédure civile au niveau européen. Ce que je peux vous dire, c'est qu'en France, finalement, cette norme n'a fait l'objet d'aucune appropriation sociale. Et j'attendais, et je suis vraiment désolée aussi parce que j'attendais un retour par plusieurs tribunaux de commerce en France qui avaient de temps en temps entendu parler de cette procédure. Alors, je n'ai pas eu de retour précis, donc je ne peux pas vous donner des chiffres. Simplement, ce que je peux vous dire, c'est qu'ils maîtrisent tellement peu la procédure qu'en fait, ce sont les magistrats eux-mêmes qui se téléphonent et qui se disent « Mais toi, tu as déjà utilisé cette procédure, est-ce que tu peux m'expliquer comment cela fonctionne ?» Alors, un système de précédent très informel. Sinon, on ne sait pas aujourd'hui utiliser cette procédure en France et finalement, on ne souhaite même pas l'utiliser. Merci.
Ok. I think this is will deliver. It will give us very interesting points for comparison. To summarize, maybe I can say that in France there is certainly a growth of cases in the subject, and Alexandra has interviewed judges just in order to know why the procedure is not used much. It is about 1% of all small claims cases is European small claims cases, and this is not very much. Most of these cases concern defective goods that are then argued about by consumers, and the judges replied that the consumer does not know the procedure, but then Sandra has found out that the judges do not know the procedure either. Many of them do not know. So she told some anecdotes about judges that phone each other up in order to know whether the other one has already used the procedure or not, and if he has used it, could he please explain how it worked. So there are some, she has also asked what, according to the judges, would be the problems, or the perceived problems for the justiciables, and the aspect that came out most clearly was the language issue, and this is because the amount of the claims are usually so small that it does not justify or does not merit the costs of translation involved, and this may result in the procedure not being used at all. And then she said for the future it's difficult to say which will happen. The future may be affected by the fact that the cases will be taken over by the Tribunal d'Instance, and the procedure which is more known in France is the European injunction to pay procedure. So she concludes that, and this is where she interacts with Sandra, that the social acceptance of the procedure still can be much improved. And she thanks.
Thank you again, Alexandra, for your presentation, and Nanette for your excellent translation. So now I will give the floor to Professor Maria Pila from Bilbao.
Everyone accepted this procedure as a huge change, and it was seen as a way where companies could adjust to the prices. What is real is that Spain is suffering at very, very big prices, and it's clear also that this is implying a huge change in the structure of commerce inside Spain. Companies are closing in an incredible way. This implies that there are lots of debts that are not recovered, and this is creating quite a social problem. So this was seen as a way of solving or helping in the solution to this problem in the doctrinal approach. But the application that we are seeing right now is very, very poor. At the beginning we said, or it was said, that perhaps also this could help to quite of change the tradition, because in Spain we don't have really developed a system of ADR. The tradition is quite against ADR, people trust judges, and then it was said, well, you know, if we don't trust ADR, if we don't trust arbitration or mediation, and with those claims that are so small, going to an ordinary court can imply a problem. This could put all the interests together. We can go to a court, but we can have a cheap and short procedure. The thing is that right now it is almost not used at all. There are 3 cases, and I'm going to talk about those cases, and you are going to see what they are doing in those cases, because if you contact the judges the most common answer that I was received is that European Union has no power to change national procedural law. This means that this is not applicable, which is something crazy when we are talking about the regulation. And when you contact the lawyers, because I contacted the Bar Association in order to see how they feel about this, they again don't know about the situation. So even when the doctrinal approach was very pro the regulation and it was foreseen as something that could be very useful for the society, in practice it is not being very used. Nevertheless, we have some things that go against what I'm saying, and this is what I want to show you. The same as you did, I was thinking, or I was trying to make a reflection about why can we have this situation. And then I thought that perhaps, also because of the conversation that I was having with lawyers, what they told me is that we must keep in mind that we are talking about private international law. So we are talking about a very low amount of money, but we are talking about transnational cases. We are not using this for national cases. And then we face the problems of private international law. When we go to jurisdiction issues, we have to take into account that the personal scope of application of this regulation is not the same as Regulation 44. This means that in some cases we have to use Regulation 44 in order to determine jurisdiction, that in a very relevant number of cases we cannot use Regulation 44 in order to use this procedure. So we can be using internal rules of jurisdiction, but we are able to use it, we would be able to use this situation. This means that with rules of jurisdiction we have to face if it is possible or not to protect consumers with those rules, because we must take into account that perhaps it's not reasonable for us to think that a consumer is going to use any procedure if he needs to make the litigation in a foreign country. Then I think that perhaps if we go deep in this procedure, or if this procedure is well known, we can know that everything is written. We can do lots of things through the conference because it is allowed by this regulation, but then we have to fit those things with the national rules. And in Spain, this is something that is not clear at all. So what I would say is, sometimes we can use rules of protection of consumers for jurisdiction. In certain types, we cannot use rules of protection for consumers. So when we are talking about consumer protection, perhaps we are facing cases where the consumer needs to go to a foreign country to begin a proceeding. And then, even if it is cheap and short, it is very expensive for them. The next thing is applicable law. And this is another big issue dealing with this. If we are talking about transnational cases, because we still don't have this common European sales law and we don't have a common rule inside Europe, then we have to go to the application to national laws. And then the fact that the court has jurisdiction to solve a case does not imply that this court is going to use the same legal system. This means that we can be facing a relevant number of problems where we cannot use the legal system of the court that is seized, meaning that the parties need to spend a very relevant amount of money in order to prove the foreign legal system that we have to use for this issue. So if we are talking about such a low amount of money, but then the cost of the procedure is so high, then this is good for nothing. I mean, you are going to spend more money in the procedure, even if we have this, than you are going to obtain in the claim. And then we go to enforcement. And I was including here the system of enforcement in Spain because, again, sometimes we cannot use the European Union regulations for enforcement. And I wanted to include this in order for you to compare the system that we have with the system that is created by this regulation. Because you know the system of Regulation 44, but look at the system that we have in Spain for enforcement of foreign judgments. This is the procedural law in Spain. It is 1881, the one that is in force for enforcement of foreign judgments, and the conditions for enforcement of foreign judgments in Spain are absolutely crazy. Are absolutely crazy because they in a huge number of cases you have there, and we have no time to develop this, I'm open to questions after. In a huge number of cases, for national courts, it is the common thing not to enforce foreign judgments. If you put this tradition that is inside the mind of all the courts, together with this system that includes no enforcement at all, I think that this can create a shock in the legal system. That was not foreseen by the doctrine, because no one was talking about the problems that we could face if we are talking about public order, for example. In Spain, I cannot imagine a court that would enforce a judgment against public order, and in most of the cases, or in a very relevant number of cases, Spanish courts include inside the concept of public order jurisdiction issues. And this regulation does not cover jurisdiction issues. So I think that this is a very big thing that we have to keep in mind. It is absolutely not a problem that is created by this regulation, but it is something that goes together with this regulation, and I think, if I make a reflection, that this can be something, all those things can be something that goes against the real application of this system. Also, when we are talking about consumers, and business, if we are talking about business to business, then I think rules are easier. But if we are talking about consumers, we have to face that there are relevant cases where consumers do not receive protection of rules of consumers. And I'll give you an example. Imagine that we are talking about a case of antitrust where a company receives an administrative fine saying that there was abuse of dominant position, and then lots of consumers suffer a harm. This is quite easy because you have the administrative sanction and then you know the harm, so it is quite easy to prove this. Okay, the consumer in this case that is suffering the problem cannot receive the protection of the rules of consumers because there is no contract. And for receiving protection of the rules of consumers, we say consumers, but it is consumer contracts. And here we are not talking about contracts. So imagine that we have one of those agreements between companies of raising prices, and the consumers receive a harm. The consumers need to present the claim against the producer, not the seller. And then again, we are facing problems where we have consumers, but we are not creating a system of protecting consumers. How could we solve this? Using autonomous concepts of inside this regulation. I mean, the concept of consumer that we have in the ordinary rules in Regulation 44, for example, is not good enough for this. Okay, let's create an independent concept for definition of consumers in order to use this. Or now that they are talking about the change in Regulation 44, let's put together Regulation 44 with this, and let's try to create a forum of international jurisdiction that puts the case at home for the consumer. And I think that this really would help in the solution of this. Also, I would say that the procedural law in Spain, and I included here this slide just to show you what we have, I think that the internal procedural rule is quite complex, and we have a mixture of matter of the case together with the quantity. So those are procedures inside the Spanish legal system. If we put together these small claim procedures with this, I understand that it is quite difficult for the people to see if they are going to use one or the other. And there's a huge tendency of going to the procedure that they really know. So I think that those are things that we have to keep in mind. Dealing with the structural issues, I would say that in Spain there's a specific issue that is relevant, that we use something that I would say procuradores, the translation that I found is court lawyers. It is something that is quite special from our jurisdiction, that it is, in order to explain you, it is legal trained person that helps the lawyer in the proceeding issues. And this implies a cost that is incredible if you take a look at it in a reasonable way, that it is protected by the law. now with the directive of services, it was a huge debate if this should have to continue or not. The law that was going to be passed through the parliament in Spain contained the disappearance of this institution, but at the end of the day, because of lobbying of this group of people, they continue to exist. So this implied an additional cost in the procedure that we have to keep in mind. I'm going to pass this because I'm running out of time, because I want to tell you the cases that we have faced in Spain, those that are that have been reported. This one is a case that only implies a misunderstanding, because the plaintiff tried to use this regulation in order to create a forum of international jurisdiction. So he considered that Article 3 of this regulation implied a forum of international jurisdiction when it is clearly not the case, and then the court just considers that the rules of international jurisdiction need to be internal rules, Regulation 44 or regulation or internal law. But the thing is that this is one of the cases where we cite this regulation. And the interesting cases that I wanted to talk about are two cases that both of them come from Madrid, but from different courts. And I think that this is a very interesting issue, because what we have in those cases, that is this one that I show you, 2010, and this one, 2008, and they are almost the same, is that they are using this regulation, the small claims regulation, in an internal case, in an absolutely domestic case. Of course, not for using the procedure in this case, because it would be impossible, but in order to use the definition of counterclaim that is contained in this regulation. Even when the regulation is not applicable, because the procedure is an ordinary internal procedure, the judge in both of the cases, and this is why I found it quite interesting, because it is two different judges, the court considers that we should have to have an harmonic interpretation in the procedural concepts that we use in the different legal bodies that are enforced in certain legal systems. And I found that this is a clear answer to the question, this helps integration, or this helps the harmonization of procedures. If we begin having judges that use those concepts in order to find different objects, that this really creates a system of harmonizing our procedural laws in Europe. And I think that harmonization of law in Europe, or unification of law in Europe, would really be the way of having those procedures used. The conclusion that I wanted to use is that I think that with this procedure we face problems, but I don't think that the problems that we face are created by this regulation. So what I think is that we should have to push further for more visibility of this procedure, because I think that if the lawyers and the courts know about it, I think that they are going to love it, because it simplifies, it lowers costs, and I think that this is something that we have to keep in mind. And I think that we should, or we could make a proposal of harmonizing the use of the different European Union instruments in order for them to work together in a better position. Thank you.
I teach private international law at the University of Bologna, and I had the chance to participate in the negotiation of this regulation 6 years ago in the delegation, Italian delegation at the Council of the European Union. So I had the chance to see these rules, how they were adopted at the Council of the European Union. And later on, I saw how these rules were adopted, were implemented and applied in all the national member states, or at least in Italy, where I live and work. I will be very brief as concerns the implementation and the application of small claims in Italy, since, as my European colleagues said before, I do not have any surprise in this sense. So also in Italy we don't have a huge application of this regulation. At least I can tell you that there are from 2008 until now at least 100-150 cases registered at national level. And on this point I can raise the first problem with small claims, the fact that there is, at least in Italy but in many member states, a case management system that will be very helpful to understand how many cases, how they can be handled by the national courts. There is no case management system. So basically, national researchers have to do their best in order to understand, to go to the courts, understand which is the situation. Me personally, as my colleagues, I interviewed the courts, the clerks, and I also had the chance with my working group to do something more. Another way to simulate a small claim, a submission of a small claim by foreign claimant in our courts. So I arranged an agreement with 2-3 Italian courts in order to simulate a small claim by foreign claimant with all the national procedures, rules as it was real. No? And the result has been quite surprising, no? Because basically foreign claimant has to face so many problems in submitting a small claim before a national court that basically he's disencouraged to enter in this procedure. More precisely, if a foreign claim wishes to submit a small claim in Italy, and there is a lower court system in Italy, there is the Justice of Peace in Italy, which is competent until 5,000 euro claims. This value has been raised in 2010, so 5,000 euro. So if a foreign claimant wishes to submit a claim in Italy, first of all he has to face the first and main problem, that he doesn't know where is the court he or she must seize. Because no specific information on the address, on the contacts of single specific justice of peace in Italy, but it is not so only a problem of Italy, are available on the portal of European Judicial Civil Portal, no? Atlas, as you know. So basically, and this information are not updated. My foreign claimant tries to send by post a small claim in Italy, and basically he received back his claim because the address was unknown. And the address was basically on the European Justice Portal. So first of all, basic information on the address, on the contacts of the Justice of Peace. Because at least in Italy you have 300-400 Justice of Peace. It's a very decentralized system, no? Even in the small villages there are Justice of Peace. And if I want to submit by post from abroad, I have to know which is the specific address. First of all, this problem. Secondly, a foreign claimant is not aware about the submission methods. No? This is a very important point, because if we imagine that this regulation helps foreign claimant from his sofa, from his room, to submit a claim, we must help him to use as far as possible posts and electronic means in order to submit claims, in order to avoid for him to go to the national court, to the foreign court. And no specific information on this method of submission are provided on this portal or in other ways. So, for example, they did not know how to submit this claim. And so he was encouraged, in some sense, to appoint someone on place in order to personally lodge the claim at the sixth court. Now, the second problem is a practical problem. Then a problem which has not been yet treated by my other colleagues, which is the problem of the payment of the court